framework of the EPA. Federal and state civil and criminal justice systems conduct hearings usually in an adversarial rather than inquisitorial way. Generally, the way in which this works is that two or more parties will state a case to the court and present evidence to the court in support of their cases, and it's the job of the court, based on that evidence, to decide which case is preferable or correct. The Environment Protection Act, which was enacted in 1970, provides the legislative framework in which the EPA operates. It's the enabling legislation that brings the EPA into existence, and it is the source of all of the powers and functions that the EPA has to conduct its activities. The EPA Act is understood to express the will of the public of Victoria through our democratic system of government. Parliament has, in doing that, specifically included a number of provisions that create criminal offences. The EPA, when prosecuting criminal offences under the EPA Act, operates in the criminal rather than the civil justice system. However, a number of the enforcement options or compliance activities that the EPA conducts are also engaged with the civil justice system. When the EPA conducts criminal prosecutions or is involved in criminal proceedings, and it is required to prove a fact or matter, it needs to do so beyond reasonable doubt. Also, an important difference with criminal proceedings is that the accused person is entitled to know the case that the EPA is intending to present in court and to know all the evidence that the EPA intends to present in support of its case. There are four key acts that apply to criminal proceedings that the EPA is involved in. The first is the Evidence Act, which contains rules and procedures for the admission of evidence in criminal proceedings. The second is the Criminal Procedure Act, which sets out the framework for the conduct of criminal proceedings, and that includes proceedings in the Magistrates' Court and in the higher courts when the EPA is conducting or prosecuting indictable offences that must be tried before a jury. The third act is the Sentencing Act, which provides the rules and principles on which the courts will impose sentences on people who've been found guilty of criminal offences. And fourthly, the EPA Act itself, and in some cases, the subordinate legislation or regulations that are made under the Act, which provide the source of the criminal offence provisions which the EPA Act prosecutes. All of these acts and the provisions contained in them provide the framework within which prosecutions are commenced and conducted in Victoria and by the EPA in particular. That concludes the presentation on the legal framework of the EPA. If you have any further questions about the operation of the EPA Act or the legal framework within which the EPA operates, feel free to contact somebody from the Legal Services Unit to provide further advice or assistance. Thank you for listening.